Contracts under seal represent one of the oldest and most formal types of legal agreements in common law. While their importance has diminished in modern times, understanding these specialized contracts can still be crucial in certain legal situations. A contract under seal is a formal written agreement that derives its validity primarily from its form rather than from consideration. Unlike standard contracts, sealed contracts are enforceable without requiring something of value to be exchanged between parties. They simply need to be signed, sealed, and delivered to be valid. Historically, these contracts were authenticated with wax seals pressed with signet rings. Today, the seal might be as simple as the word seal printed next to a signature, the phrase locus sigilli or LS appearing on the document, or an embossed impression similar to a notary seal. These specialized agreements go by several names including common law specialty, specialty contract, covenant, sealed contract, deed, or special contract. What sets them apart is their formality and the fact that they carry an irrefutable presumption of consideration. Despite their decreased prominence, contracts under seal still appear in several important contexts. They remain common in real estate transactions and deeds, construction contracts involving long-term performance, government contracts, loan agreements with extended repayment terms, and certain corporate documents like board resolutions. The legal significance of sealed contracts varies widely by jurisdiction. In states that still recognize them, sealed contracts offer distinct advantages. They may be presumed valid without showing consideration. They often benefit from extended statutes of limitations. While standard contracts typically have limitation periods of 4 to 6 years, sealed contracts might extend this to 10, 12, or even 20 years. For example, in the District of Columbia, actions brought against instruments under seal have a 12-year statute of limitations, compared to just 3 years for ordinary contracts. Georgia takes this even further, allowing a 20-year period for sealed contracts, giving creditors significantly more time to pursue debts. However, many states have eliminated or significantly reduced the legal distinction between sealed and unsealed contracts. California, Texas, and New York have largely abolished these differences. The Uniform Commercial Code has also removed the distinction for contracts involving the sale of goods. Before using a contract under seal, several practical considerations should be evaluated. First, determine whether your jurisdiction still recognizes sealed contracts. If not, adding a seal provides no benefit. Consider the type of contract. Seals typically matter more in construction, real estate, or formal lending agreements. Ask yourself if you need an extended statute of limitations. If potential disputes might arise years after execution, a sealed contract could provide valuable additional time to bring legal claims. Also consider whether both parties understand and agree to the seal's legal effect. To avoid disputes, explicitly clarify the intent of using the seal in the contract language. The modern landscape of sealed contracts varies dramatically across states. Georgia and North Carolina maintain the distinction, allowing sealed contracts to benefit from longer enforcement windows. Meanwhile, states like Illinois and New York treat sealed contracts no differently from standard ones. Some jurisdictions accept printed versions of the word seal or abbreviations, while others may require physical embossed or notarized seals. This patchwork of regulations makes it essential to verify your state's position before relying on a seal for legal protection. In summary, contracts under seal represent a formal agreement type with historical significance that continues to impact modern legal practice in certain jurisdictions. While their importance has diminished, they can still provide extended enforcement periods and presume validity in states that recognize them. Understanding whether your state honors sealed contracts and in what context can help determine if this ancient legal device still offers meaningful protection or is merely a formality.